Welcome to Civil Procedure, Subject Matter, Jurisdiction, Video 1. Yes, we made it to Subject Matter Jurisdiction. Now, we were unable to videotape class on Wednesday, September 24th, and we were also unable to open the Zoom for those participating by Zoom on Wednesday, September 24th. So this lecture is going to serve as the lecture for Wednesday, September 24th, when we introduced subject matter jurisdiction. Excellent. Up until now, we've been focused on personal jurisdiction. And the question there was, does this court have power over this defendant? Today, we turn to subject matter jurisdiction, where the question becomes, does this court have power to hear this kind of case? Does this court have power to hear this kind of case? Unlike personal jurisdiction, subject matter jurisdiction is non-waivable. Because it's non-waivable, it can be raised at any stage of the litigation, even sua sponte, which means even by the court itself. The very fact that we are asking what kind of case the court can hear tells us immediately that our focus now is on federal courts, because federal courts cannot hear every kind of case. And if we're asking about the judicial power of federal courts, that means we have to go to the United States Constitution. To understand subject matter jurisdiction, we begin with the Constitution itself. Article 3, Section 1 establishes the Supreme Court of the United States. Article 3, Section 1 also gives Congress the authority to create lower federal courts, what we call, or what the Constitution actually calls, inferior courts. And Congress has the authority to create those inferior courts from time to time as the Congress deems necessary. So let's jump over and let's take a look at Article 3, Section 1, so that you can see it for yourself. I've identified a few, well, really not few, I've identified 3 clauses that are of import in our conversation about judicial power. The green highlight is the vesting clause, and that is where Article 3, Section 1 sets out the creation as a shall of one Supreme Court. I highlight in blue the inferior court clause, which is where Congress has the authority from time to time to ordain and establish inferior courts as they deem. And then I highlighted in yellow the good behavior clause, because it's always fun to know that justices in both the Supreme Court and the lower federal courts have a requirement to serve in good behavior. And for all intents and purposes, good behavior means that as long as they are serving in good behavior, these justices have lifetime tenure, right? And the clause also says that they should receive compensation, and that compensation may not be diminished, but of course it can be increased. Now, let's just take a theoretical moment and consider, why did the framers design this section this way? Specifically, why did the framers give a tenured position, a lifetime position to justices? Think about it. The theory is that it's to insulate the judiciary from political pressures, right? So courts are meant to interpret and apply the law. The goal is for courts to do that without fear of being punished for unpopular decisions. And so some of the way of securing you from the fear of retribution is to give you tenure. And as long as you act within good behavior, however that is defined, then your job should be secure. Okay. Moving on to Article 3, Section 2. This one's big. This one's big. Take a minute. I know that there's a lot of stuff going on there, and I did that intentionally. And I tried to keep it as minimal as possible, but there were certain things that I thought were important to highlight. So now that we've seen how Article 3 establishes the courts and secures judicial independence, that was Article 3, Section 1, we can look at what kinds of cases these federal courts can actually hear. And Article 3, Section 2 holds that answer. Think of Article 3, Section 2 as a menu of judicial power. It lays out the maximum reach of federal jurisdiction. If cases don't fit within one of these categories, that's in Article 3, Section 2, then federal courts do not have the authority to hear the case. It's really pretty simple, right? It's really pretty simple. So with that being said, we can also say this. Article 3, Section 2 is the starting point for all things subject matter jurisdiction. Article 3, Section 2 is the start of all things that are subject matter jurisdiction related. The yellow highlight speaks to judicial power. So it says the judicial power shall, right? The green highlight, this is the arising under clause. We'll talk more about that when we get to federal question. The blue highlight gives you what types of cases that can be heard. And I didn't highlight all of it in blue because, again, I was trying to make this not overwhelming with arrows and colors, but I did want to highlight some things. If you look at the olive green, where it speaks to between citizens of different states, that's our diversity jurisdiction clause. And we're going to jump into diversity a little bit later, but that's our diversity jurisdiction clause. If you go to the second paragraph where it says, in all, let's read that. In all cases affecting ambassadors, other public ministers, and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. So, what types of cases can you file in the Supreme Court as the initial filing? Cases affecting ambassadors, cases affecting public ministers, cases affecting councils, and cases in which a state shall be named a party. The Supreme Court shall have original jurisdiction. Yeah. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, right? Shall have appellate jurisdiction, both as to law and to fact. Here's where that shall isn't really a shall. The exceptions and regulations clause, right? With such exceptions and under such regulations as the Congress shall make. So, as to the United States Supreme Court, the Constitution allows the Congress an opportunity to check not the original jurisdiction of the United States Supreme Court, but to check the appellate jurisdiction. What types of cases the Supreme Court can hear on appeal? It's all very amazing when you allow yourself to really become immersed, when you allow yourself to really become immersed. Okay? Now, the first limit on federal judicial power. Remember, Article 3 is the ceiling. Article 3, Section 2, when it comes to what types of cases the court can hear, right? Article 3, Section 2 is the upward bounds. The upward bounds, yeah? Let's look at one of the first limits of this judicial power. Congressional statutes. Congressional statutes. It is Congress who decides how much of Article 3, Section 2's power the courts actually can exercise. It's Congress who can grant the full extent or can grant less, right? It's Congress that serves as the first limit on federal judicial power. Federal courts cannot hear cases. Pause is intentional. The repeat is intentional. Federal courts cannot exercise subject matter jurisdiction unless both the Constitution authorizes it and Congress has passed a statute to enable it. If the Constitution authorizes it, but Congress has not enacted a statute to enable it, the court cannot act. That's what we mean when we say that federal courts are courts of limited jurisdiction. The first limit comes from Congress enabling action via a statute or not. Now, by contrast, state courts are courts of general jurisdiction. They can hear almost anything. Federal courts are courts of limited jurisdiction. They can exercise subject matter jurisdiction over the types of cases that the Constitution identifies and where Congress has enacted a statute. I know that was really slow, but it's really important. I know that was really slow, but it's really important. This leads to an essential distinction between constitutional jurisdiction versus enforceable jurisdiction. Article 3, Section 2 is permissive. It sets out what the judicial power may include, but the Constitution is not self-executing. The Constitution does not, by itself, give lower courts subject matter jurisdiction. Congress must act in order for federal courts to actually be able to exercise subject matter jurisdiction. Unless Congress passes a statute conferring jurisdiction, for example, 28 U.S.C. 1331 for federal question jurisdiction, or 28 U.S.C. 1332 for diversity jurisdiction, the federal courts cannot exercise either federal question jurisdiction or diversity jurisdiction. So here's the formula. The Constitution says that it's possible. Congress enacts a statute that says it's permissible. The Constitution says that it's possible. Congress enacts a statute that says it's permissible. Again, without both, the case must be dismissed. Does not matter how compelling the facts are. Does not matter personal jurisdiction. Does not matter notice and service of process. Does not matter. Right? I'm going to let that sink in and remove it. Okay. The second limit on subject matter jurisdiction, right? Second limit on federal judicial power is the cases and controversies provision. It's the cases and controversies provision. Federal courts may only adjudicate actual disputes between adverse parties. Federal courts may not issue advisory opinions or step into political questions, right? That's how we get to doctrines like standing, ripeness, and mootness. So allow me this indulgence. Let's go back a couple of slides. We're going to go back to slide 6. We didn't talk about this the first time we looked at slide 6, and that was intentional because I want to talk about it now. You see in red, I have highlighted all cases, ... all cases, ... all cases, ... controversies, ... controversies, ... When we say that federal courts are only allowed to hear cases and controversies, these are the cases and these are the controversies. Well, we already know that these are the types of cases that the court can hear, but the case actually has to be alive, and the case must also be between adverse parties. The case must be alive, and the case must also be between adverse parties. So, because of this cases and controversies provision, we have what we call justiciability doctrines. Justiciability doctrines. You're going to learn more about these doctrines when you get to federal jurisdiction. But even now, it's important to know that these doctrines exist because we're talking about, can the court exercise authority? Why? Because what we're trying to get is a valid order. Oh, that's right. We got to have a valid order. All of this plays into whether or not we can get a valid order. Okay. So With these just disability doctrines, and you're going to learn a lot more about them, but we have five primarily. Standing, and standing is a establishment. That's what it is. It's an establishment that the plaintiff has suffered an injury in fact, right? The injury must be fairly traceable to the defendant. In torts, we'd call that causation. And the injury must be redressable by the court. Well, that makes sense, because why would you allow a plaintiff to start a lawsuit if the plaintiff hasn't in fact suffered the injury? And why would you allow the plaintiff to file a lawsuit if the plaintiff has in fact, and that in fact, that's a term of art, that's in, right? That I'm not just saying in fact, I'm saying an injury in fact. Even if the plaintiff has suffered an injury in fact, if the injury isn't fairly traceable to the defendant, then why file the lawsuit, right? Because you're not being able to establish the causation. And if you do have a plaintiff who has an injury in fact, and if that injury is fairly traceable to the defendant, but there's no redress available, that means that the law doesn't provide relief for that type of injury, then why file the lawsuit? So standing is huge. Ripeness is the case must be ready for judicial opinion, can't be premature. Mootness is the case has to be alive throughout the litigation, right? When we did Asahi under specific personal jurisdiction, and the California domiciliary who filed the suit ultimately settled, if there had not been a third party complaint filed, right, the case would be moot, because by the time it got to the Supreme Court, the original plaintiff had settled the case. Well, we don't need redress. Now there was a settlement. Yeah. Political question is when certain issues are committed to political branches, which means that the court's not intended to adjudicate it because it's reserved for a different branch of the government. And then advisory opinions. Federal courts are not supposed to give legal advice, right, outside of concrete disputes, which is resolving the dispute. So I know that was a little bit of an aside, but that aside was most definitely worth introducing now. So let's get back on track. We've now established two constitutional limits on federal judicial power. The first is federal courts may not exercise subject matter jurisdiction unless it's authorized by Article 3, Section 2, and there's a congressional enactment. There's a statute that's been enacted by Congress that gives permission for the court to actually act. The second limit that we've discussed is federal courts can only adjudicate cases where there's a case or controversy, which got us to the justiciability doctrine. With those constitutional boundaries in place, we now turn to an example of congressional enactments. Income 28 USC 1331, which is federal question jurisdiction, and 28 USC 1332, which is diversity jurisdiction. Please allow me this indulgence. I'm going to go back to slide 6. See how important slide 6 is? Remember when I said in law and equity, this green highlight, this is our arising under. This is where the Constitution has given authority. 28 USC 1331 is the congressional enactment counterpart for this arising under in the Constitution. So the Constitution says arising under. Congress says, great, here's your authority to act. Congressional Statute 28 USC 1331. Same thing with diversity jurisdiction. See where the Constitution says that federal courts can hear cases between citizens of different states. Great. The congressional enactment, the statute that's the counterpart to this is 28 USC 1332. See how it works? Without 28 USC 1331 or 1332, we have the possibility of this action here in the Constitution, but we don't actually have any authority. We don't have the permission to actually do anything with these terms of art within the Constitution. Okay, great. Let's go back to slide 10. Okay. What are we going to do first? We are going to begin with diversity jurisdiction. There's 28 USC 1332. Federal rule, no, not federal rule, civil procedure. This is a statute. There's the citation for the statute, 28 USC 1332. Pull it up. 1332A says, the district courts, these are federal district courts, these are trial courts, shall have original jurisdiction of all civil, not criminal, all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and cost, not $75,000 with interest and cost, but it has to exceed $75,000 plus interest and cost. And let's go to one, is between citizens of different states. Now, 1, 2, 3, 4, it's all part of the statute, but we're going to start with 28 USC A1. So in order for the federal court to exercise diversity jurisdiction, two things have to happen. There has to be an amount in controversy that is satisfied, that's over $25,000, see, exceeds the sum, we'll get to that when we talk about aggregation of claims, but exceeds the sum of $75,000 and is one of four. We're going to stop at one, citizens of different states. That's where we're starting. Okay. That's what we're looking at. Take a minute if you hadn't looked at it already. Yeah. Thoughts? No. This statute, 28 USC 1332, is crucial because it represents Congress's decision on how much of Article 3's potential judicial power to give the lower courts. Remember, Article 3 would allow even minimal diversity. Do we need to go back to Article 3? Let's go back to Article 3, slide 6. Between citizens of different states. It's all it says. Doesn't give any, right? These are the upward, remember the Constitution is the upward infinity and beyond possibility. We have to look to Congress to narrow that, to limit that, to be the floor of that potential. It doesn't give any indication of anything, right? Well, all right, let's go back to 28 USC where we are right here. Neither does the statute, though. Neither does the statute. The statute just says citizens of different states. Hmm. Hmm. So, what is this talk about minimal diversity and complete diversity? Because neither Article 3, Section 2, nor 28 USC 1332 tells us if it needs to be minimal diversity or complete diversity. But more importantly, please allow me go back to 6. Read Article 3, Section 2. You can read it from the beginning to the end. You're going to see that there's nothing in Article 3, Section 2 when it comes to diversity jurisdiction that speaks to a minimum amount in controversy. Mm, mm. Well, the statute does, though, right? Which is, right? That's why we have to look to the statute, because the statute actually gives us the marching orders. But all of this gets rather interesting when you think about it. Well, let's just keep going and see what we find out. Let's go to our first case. Strawbridge v. Curtis. Now, I know in the reading, we actually have Gordon v. Steele first, but that's okay. That's okay, because we're going to get to Gordon v. Steele. But before we get to Gordon v. Steele, I want to start with Strawbridge versus Curtis. Okay? I want to start with Strawbridge versus Curtis. Yeah? You there? I want you to be able to pull out your notes and okay. At first glance, 28 USC 1332 seems pretty straightforward. Citizens of different states, right? At first glance, well, Article 3 seems pretty straightforward. Citizens of different states. But here's the question. How much diversity is enough? How much diversity is enough? Does the statute 28 USC 1332 require at least one plaintiff be from a different state than at least one defendant? Because if it's one plaintiff and if it's one defendant, making sure that they're both from two different states, that's relatively easy. But easy is not the practice of law, right? Easy is on one of those random days where it's just easy. Those aren't the normal days. The normal days is that it's just going to be complex. So if I have multiple parties, as long as one is diverse on the plaintiff from one that's diverse on the defendant, is that enough? Right? Because if that's enough, that's actually what we call minimal diversity. Minimal diversity is when at least one plaintiff is different than at least one defendant, right? Or is what is required complete diversity, where every plaintiff must be different from every defendant? Well, this is the question that came before the United States Supreme Court in 1806. 1806, and the Strawbridge v. Curtis case. Chief Justice John Marshall answers this question. And the answer to this question is the baseline rule that we follow in 2025. That's why we're talking about an 1806 case, because that case set the baseline for diversity as we practice it today. Let's turn to Strawbridge v. Curtis. The plaintiffs in Strawbridge argued that because there was at least some diversity among the parties, the case should be allowed in federal court. Some diversity, basically, they're arguing for minimal diversity. Their reasoning was simple. Article 3 of the Constitution says federal judicial power extends to controversies between citizens of different states. On its face, that language only requires minimal diversity. That's at least one plaintiff is different from at least one defendant. But in Strawbridge, the United States Supreme Court sees this differently, and as a result, is going to give us the holding that directs us. Here's some facts. Because you're going to read it, you're going to identify the facts that are relevant. The case involved a land dispute in Vermont. We have multiple plaintiffs and multiple defendants. Some plaintiffs and some defendants were citizens of the same state. Plaintiffs argued minimal diversity is all that's required from Article 3. Now remember, this is 1806. Remember, this is 1806. In 1806, we didn't have 28 USC 1332. We didn't have 28 USC 1332. But even in 1806, it was understood that Article 3 gives you the possibility, but you still need a congressional statute to actually exercise the subject matter jurisdiction. So we knew that even in 1806. Okay. And so when the plaintiffs argued minimal diversity was enough to satisfy Article 3 standards, the defendants countered in their argument and said that the Judiciary Act of 1789, specifically Section 11, required complete diversity. How do we get to the Judiciary Act of 1789? We need a congressional enactment. We've got to have a statute, right? At the time, it was the Judiciary Act of 1789, right? Because the Judiciary Act of 1789, as you will find out in federal jurisdiction, was the almost go-to congressional statute for just about all of the necessary power finding for the court to actually take action. What's the issue? Under the Judiciary Act of 1789, which grants federal courts jurisdiction over controversies, see, it's here, right? This section is the predecessor of 28 USC 1332. Under the Judiciary Act of 1789, which grants federal courts jurisdiction over controversies between citizens of different states, does diversity jurisdiction exist when only some parties are diverse, or must every plaintiff be completely diverse from every defendant? Under the Judiciary Act of 1789, does diversity jurisdiction exist when only some parties are diverse, or must every plaintiff be completely diverse from every defendant? You know, I like my maps. I love my fact element maps. So let's look at Strawbridge v. Curtis, fact by fact, and see how each fact tied to the rule is used in the court's analysis. First, as you read, I hope you were keeping track of what party was from which state. What party was from which state, right? So some plaintiffs, some defendants, citizens of the same state. What element are we looking for? We're looking for diversity of citizenship under the Judiciary Act of 1789, because we've got to have a statute, right? How did the court apply that to get an outcome, overlap in citizenship, according to the Judiciary Act 1789, Section 11, destroys complete diversity. How did the court use that? Honorable Justice John Marshall said that the statute must be read to require every plaintiff be diverse from every defendant. Seems like I got my answer right there, right? Seems like I got my answer right there. Second, it's true that at least one plaintiff was diverse from at least one defendant. That's a fact, right? What element am I talking about? If I'm looking at this fact, well, I'm looking at minimal diversity under Article 3, Section 2, because it just says between different states, right? What's the court's application? Constitutional sufficiency is not enough. Constitutional sufficiency is not enough. I've got to act based upon the congressional enactment. I have to act pursuant the statute, right? And so constitutional sufficiency doesn't satisfy the statute when the statute says that if you've got overlap in citizenship, you're not going to have complete diversity, right? The court clarified that Article 3 sets the standard. Article 3 sets the standard. Okay, well, let's go to the third one. Judiciary Act of 1789 granted jurisdiction over suits between a citizen of one state and a citizen of another state. That's the statutory grant, right? Justice John Marshall read that language to require complete diversity. The court interpreted Congress's statute narrowly, thereby limiting the jurisdiction. See how it all works? See how it all works? The text of the statute mattered. The Judiciary Act of 1789 said federal jurisdiction exists over cases between a citizen of one state and a citizen of another state. Done. Justice John Marshall read this as requiring complete separation of citizenship on both sides of the V. That's the verses, right? The plaintiff on the left side of the V has to be different than the defendant on the right side of the V. Yeah. Finally, because the plaintiff still asked the federal court to hear the case, despite the overlap, Justice Marshall emphasized a basic principle. Federal courts are courts of limited jurisdiction. They can only hear cases if both the Constitution authorizes it and Congress creates a statute. Simple, complete diversity was missing, and so the case was dismissed by Strawbridge. So when we talk about diversity, do you need to spend a lot of time talking about minimal versus complete? No. Because what is the standard since 1806? Complete. Is Professor Washington going to ask questions about minimal diversity? Why would I? The standard is complete diversity. All right? Questions? If so, write them down. If you've got questions, write them down. After Strawbridge, we know the rule. Complete diversity is required. Every plaintiff must be completely diverse from every defendant. Every plaintiff must be completely diverse from every defendant. Now, that does not mean that I can't have multiple plaintiffs in a case and the plaintiffs be from the same state, or multiple defendants in a case, and the defendants share the citizenship of a state. But I can't have it cross the V, right? If I have a plaintiff from Texas and a plaintiff from California, my defendants have to be from someplace other than Texas or someplace other than California, because can't have the same state on opposite sides of the V. Okay. But now that we know that complete diversity is what is required, what does it mean to be a citizen of a state? All right. Because my plaintiffs must be citizens of states that are different than my defendants. But what does that even mean? Where do we go? Gordon v. Steele. Told you we were going to get to Gordon v. Steele. Where do we go? Gordon v. Steele. And this is the beautiful thing about the video, because class is only 50 minutes. And we are now at the videotape 47 minutes. We would not have been able to complete both Strawbridge and Gordon v. Steele in class, but we can complete them both now in the order that they actually needed to be completed, so that we have a better foundational understanding going forward. So now we get to jump into Gordon v. Steele, which we did discuss in class on Wednesday, but because we couldn't videotape it in Zoom and because the equipment wasn't working, here it is again. Article 3, Section 1332, both speak in terms of citizens of different states. Article 3 and 28 U.S.C. 1332 both speak in terms of citizens of different states. We've already decided, though, we've already discussed that neither actually defines what citizen of a state means. The courts have answered this question through the doctrine of domicile. Told you we talk about domicile. Remember, we brought up domicile when we were speaking of the paradigm for general jurisdiction as it related to an individual. Here it is. Citizenship for diversity purposes is based on domicile, not mere residence. Citizenship for diversity, and this is for individuals, is based on domicile, not mere residence. Domicile requires two elements: physical presence in the state and the intent to remain there indefinitely. A person may have a residence in many different states, but a person may only have one domicile. And you do not lose that domicile until you clearly establish a new domicile. The case that makes this crystal clear is Gordon v. Steele, divided by the Third Circuit in 1974. So let's walk through it. What are some of the facts? I did this one a little bit like I do my proof sheets when we are doing the case analysis to prepare for trial. I'm going to divide these facts up into good facts and bad facts. So if we are representing Gordon, these are going to be good facts. If we're representing Steele, these are going to be bad facts, right? Depends on upon your perspective. We want, if we're representing Gordon, to be able to establish that Gordon has a new domicile, right? We want to be able to establish that Gordon has a new domicile. So here are the facts that are going to help us do that. Gordon originally lived in Pennsylvania through high school graduation. At age 18, she moved to Idaho to attend nursing school. So her physical presence now is going to be in Idaho. While in Idaho, Miss Gordon expressed desire to remain in Idaho beyond her education. That's expression of intent to remain indefinitely. Miss Gordon obtained an Idaho driver's license. Okay, got some civic ties. She registered to vote in Idaho. Oh, that's a big deal. That's a big deal. She opened an Idaho bank account. Okay, okay, right. 1974, banks didn't have branches in every state. Um, so I believe banking was a little more local. So if I'm opening an Idaho bank, I'm kind of making some commitments that I'm going to be in Idaho. Yeah. Okay. Bad facts. These are the facts that would support that Miss Gordon is still a domicile of Pennsylvania. Miss Gordon continued to return to Pennsylvania, but she explains she was going back to Pennsylvania for medical treatment because that's where her doctors were. Miss Gordon sued Pennsylvania doctors. Well, I don't really think that that hurts her. She still has strong ties to the old state, but these were her medical providers, right? Miss Gordon maintained family and health connections in Pennsylvania. Well, excuse me. And Miss Gordon is going to remain in contact with her family. And if her family is in Pennsylvania, well, yeah, okay. Court's reasoning. Courts are going to look at the totality of the circumstances, right? Totality of the circumstances. Domicile equals physical presence plus the intent to remain indefinitely. Old domicile, Pennsylvania, continues until one is clearly established. What are my objective actions that can be shown in support of establishing a new domicile? We went over them. Yeah. Totality of the circumstances probably are going to weigh on the side of Idaho as a new domicile. Again, you know me, you know I love my charts. Okay. Let's step carefully through how the court in Gordon v. Still applied the domicile test. First, baseline. Plaintiff's original domicile was Pennsylvania. Yeah, that's where she lived through high school. That meant that Pennsylvania was her domicile of origin. Under the law, that domicile continues until a new one is clearly established. That means that Miss Gordon had the burden of showing she had actually changed her state of citizenship, right? That burden is on Miss Gordon. Next, we turn to her move. At age 18, Miss Gordon relocated to Idaho to attend nursing school. That satisfied the first requirement of the domicile test, actual physical presence. Actual physical presence. So that prong is satisfied. However, presence alone is never enough. Presence alone is never enough. We have to look at her intent. Where does she intend to remain indefinitely? Here, Gordon testified that she wanted to remain in Idaho, not just for the duration of her studies, but beyond, for her professional life, right? The court emphasized that indefinitely doesn't mean permanently, and it doesn't mean forever. It just means that you don't have a definite plan to leave. You don't have a plan to leave. Oh, well, if that's how we're going to interpret indefinite, then when Miss Gordon said that she intends to stay in Idaho for her professional career, she gets an Idaho driver's license. She has a Idaho voter's registration card, right? 1974. She has a bank in Idaho, and she has not expressed an intent to leave Idaho. That's going to weigh on the side of Idaho being her new domicile. Now, the court looked at objective evidence of Miss Gordon's intent. And this is where the case really illustrates the doctrine of the domicile test. Gordon obtained an Idaho driver's license. She registered to vote in Idaho, and she opened an Idaho bank account. Each of these acts, pretty powerful evidence that Miss Gordon wasn't just in Idaho temporarily. She was actually integrating herself into the Idaho civic and financial life. Of these, the court said voter registration was the strongest marker of intent to remain, right? But then we have the counterfacts, which were Miss Gordon continued to return to Pennsylvania for medical treatment. And of course, the very doctors that she sued are Pennsylvania citizens. The defendants argued that these ties showed that Miss Gordon was still a Pennsylvanian at heart. The court did not ignore these facts, but the court evaluated them under the totality of the circumstances. Gordon explained, she returned to Pennsylvania because her family was there and because she had long established medical providers there. The court found these explanations reasonable and temporary. They did not outweigh the strong objective evidence that her new home, her new state of citizenship was Idaho. So when the court put all of this together, Miss Gordon's move, Miss Gordon's testimony of her intent to remain in Idaho with no definite plan to leave, Miss Gordon's civic acts in Idaho, and Miss Gordon's explanations for continued ties to Pennsylvania, right? Right? The totality of the circumstances showed that Miss Gordon had established a new domicile in Idaho. Yeah, right? With Gordon as an Idaho citizen and the doctors that she was suing as Pennsylvania citizens under 28 USC 1332, what do we call that? We call that complete diversity. So take away with you this: presence plus intent, assessed under the totality of the circumstances, is the domicile test. Presence plus intent to remain indefinitely, which Gordon B. Steele explains means that you don't have a definite plan to leave, all assessed under a totality of the circumstances, is how you determine what state the party is a citizen of for diversity purposes. Yeah? How does that feel? Amazing. Absolutely amazing. We've already kind of solved the case, but let's look at the issue. Under diversity jurisdiction, 28 USC, section 1332, is a student who relocates to another state for college, establishes legal and civic ties, and expresses an intent to remain indefinitely. a citizen of that new state for diversity purposes, or does she remain a citizen of her former state? How am I going to answer this question? What is the rule of law? 28 U.S.C. 1332. What is the question? Does a college student who lived in one state before college moves to another state after college, invest civically in that new place, and doesn't express an intent to leave that place, but expresses an intent to remain there? Is she a citizen of the state where she's attending college, or a citizen of the state where she lived before college? Right? Same thing. Yeah. Rule statement: for the purposes of diversity jurisdiction, a natural person, as an individual, is deemed a citizen of the state in which they are domiciled. Domicile requires what? Physical presence in that state and an intent to remain there indefinitely. Yeah? There's a rule. Here's a sub rule. Once established, a person's domicile continues until one is acquired. Why is that a sub rule? That's a sub rule because that is not a requirement to establish domicile. What are the two requirements to establish a domicile? Physical presence in the state and intent to remain there indefinitely. When would I add a person's domicile continues until a new one is required? I would add that if my hypothetical requires me to address that. It's a sub rule because it's not a necessary requirement to establish domicile. But it is a rule, and it is an important rule, and it's a rule that's important enough for me to state if I get asked that question. There's a gazillion questions that I can ask about domicile that don't include how long it continues and when does it end, right? That's a sub rule. What's another important sub rule? Citizenship is determined as of the date the action is filed. So it's the date that the lawsuit is filed. What happens if I change my domicile after I file the lawsuit? It doesn't impact domicile, right? But that's a sub rule. I'm not going to add that unless the hypothetical that I'm trying to answer has that as part of the issue, right? Here's another sub rule. Courts evaluate domicile through the totality of the circumstances. I don't need that in my rule statement in order to get domicile. Now, I will use that as I explain how the court is going to evaluate this information. But if I'm trying to get to the doctrine of domicile, the domicile test, it's two pieces: physical presence and the intent to remain. Okay. What's the holding of the court? The court held that Miss Gordon was domiciled in Idaho at the time that she filed her malpractice suit against the Pennsylvania doctors. Although Miss Gordon had been a lifelong Pennsylvania resident and still returned there for medical care and a combination of other things, right? Her physical presence in Idaho and her intent to remain there indefinitely, supported by objective acts, established Idaho as her new domicile. She's an Idaho citizen. Silence was intentional. Think about it. See if you have any questions, thoughts, ideas. What are the doctrinal takeaways from Gordon v. Steele? Citizenship of a state is determined by the domicile. Citizenship of a state is determined by a domicile. The domicile test is the physical presence plus the intent to remain indefinitely. Residents alone is not enough. What is the presumption of old domicile? The presumption of old domicile is that you keep your old domicile until a new one is clearly established. You keep your old domicile until a new one is established. What objective evidence matters? What gets taken into consideration via the totality of the circumstances? Well, it's all of it. It's all of the things that you can think of, right? Um, these are some things that are listed, but there's other things that you can think of that aren't listed, right? Do you have a local gym membership? Do you go to a local Pilates? Do you have a a book club that you attend, not virtually but physically, right? Some of the more traditional voters registrations, driver's license, driver's registration if you have a vehicle, bank accounts, if you're in a local bank, especially, right? Where are you employed? Where are you laying your head? Do you own any property? Other civic ties? But it's all of those things. So don't be limited by the things that the court has identified, because those are part and parcel of that case. But it's all of those things. It's a totality of the circumstances, right? If you are taking an exam and you're having to address this domicile issue, when analyzing domicile, list both sides. Don't just decide that this is the answer and then you only pay attention to those facts, or that's the answer and you only pay attention to those facts. List both sides, right? List the facts that show the new domicile and list the facts that support the old domicile, and then explain, right, how a totality of the circumstances are going to point in one direction or the other. What is the timing rule? Citizenship is assessed at the date the lawsuit is filed. Later moves or changes do not alter jurisdiction once the case begins, right? Yeah, excellent. And I'm letting you think about that. Gordon teaches us how to determine where an individual is a citizen. What state are they a citizen of? But it only answers half the question. Oh my gosh, we keep getting answers only to get more questions, right? The next issue is, how many diverse parties do we need to establish jurisdiction? Is it enough if one plaintiff is diverse? Well, it seems like we've done that one before, right? So when we get to Mass v. Perry, we're going to get a even more, or maybe a greater, hopefully, maybe it's a greater, a deeper understanding of complete diversity, right? We'll get a deeper understanding of complete diversity in Mass v. Perry. But we're done. That is video 1, subject matter jurisdiction. We are in it to win it. Looking forward to video 2 as we take the next steps in subject matter jurisdiction. I'll see you on the other side.